saying a very good evening to all of you who've joined us today. We've come today for a constitutional analysis. We are a group of ordinary citizens based in Bangalore who are entering to engage deeply with the Constitution with the larger goal of building a better society understanding of people's constitutional rights. We've been organizing a series of these talks on the Indian Constitution to increase citizen engagement with it. In our previous sessions, we've examined the provenance of various constitutional ideals such as equality, liberty, freedom, and the like. During one of our sessions, we focused on the relationship between criminal law and the Constitution. Subsequently, we decided to explore other themes pertaining to criminal law in an attempt to understand underlying constitutional issues. And that's how today's session has come about. We observed the 18th World Day Against Death Penalty on the 10th of October last week, and we've had a series of excellent conversations around this issue. During our discussion today, we seek to examine the fundamental ideas around death penalty, the primary one being its constitutionality or the lack thereof. We will also endeavor to address questions concerning the constitutional rights of prisoners on death row. To take us through this very important discussion, we have with us Ms. Sahana Manjesh, beg your pardon. A very warm welcome to you, Sahana, on behalf of the organizers and also the participants who joined us. Ms. Sahana Manjesh originally hails from Mysore. She graduated from NLSIU Bangalore in 2013. Subsequently, she practiced in Delhi for 5 years, out of which she primarily represented persons on death row as a part of Project 39A for 2 years. She currently practices in Mumbai and is also involved in legal research projects as an independent consultant. So welcome to you, and we're very, very glad to have you today. Before I hand it over to our speaker, I'm just going to set a few housekeeping rules. Kindly keep your audios and videos on mute at all times. Please change your display names to your actual names so that we'll be sure of who's logged in. And if you have any questions, please feel free to type them into the chat box and we'll take them up to during the Q&A session. So over to you, Sahana.
Thanks so much, Poorna. Thank you for inviting me, and a very good evening to everyone. I hope everyone's doing safe and healthy. It's really nice to see so many people wanting to discuss constitutional issues on a Sunday evening. So I'm just really glad to be here. Thanks for having me over. So the concept of death penalty is, of course, something that evokes a lot of responses and a lot of very extreme responses sometimes. And it's a concept that we can look at from so many perspectives. You know, it's whether it's ethical or moral or philosophical or even religious. So today we'll talk about the constitutionality of the death penalty, the framework within which the death penalty sits within our constitution and the criminal procedure code as we have it today. The way I thought we could progress with today's discussion is that for the first half, I will talk about the constitutionality of the death penalty itself, as it has been debated and discussed in the Constituent Assembly debates, subsequent judgments of the Supreme Court, etc. And in the second half, I thought we could take a look at some of the additional issues that are very important and primary in death penalty jurisprudence, but don't necessarily speak to the constitutionality of the death penalty itself, as much as to its operation in the lives of a person on death. So we look at things like, say, mercy petitions and death row prisoners in solitary confinement. And then we can open up the floor for a conversation about this. Am I audible? Can you tell me if I'm audible?
Yes. Okay. Yes.
Okay. Great. So let's start at the very beginning. Let's start by looking at Article 21 of the Constitution, because this is where, of course, we understand how life and liberty has been described by our Constitution. So I'm just going to read out Article 21. The protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. Now, this phrase procedure established by law is really at the crux of the constitutionality and the debate about the constitutionality of the death penalty. And if you were to go back to the Constituent Assembly debates, the founding fathers and mothers of our constitution, so to speak, looked at how whether the phrase that we should use should be the procedure established by law, or should it be a more sort of evolved process of the concept of the due process. And in the conversations that ensued, what some of the members sort of had a reservation about was to say that if we were to use the phrase due process, then there could be judicial discretion, unappointed judicial officers, unelected judicial officers would have the right to look at legislations, and this could trample on the rights of the executive and the expanse that the executive is sort of trying to imagine for itself at that time. And the debate ultimately resulted in not adopting due process as the clause for Article 21 as it has come to be, but to say procedure established by law. And this debate didn't really end with the Constituent Assembly debates. Going forward in time, in the landmark decision of Maneka Gandhi, the Supreme Court sort of breathed life into Article 21, Article 19, Article 14 by reading all of these articles together. And the result of reading all of these articles together was to say that even when you're looking at procedure established by law, that law must be a valid law. It must be just, it must be fair, and it must be reasonable. Because, I mean, one of the very common examples that's used is perhaps to say, you can have a procedure established by law, a law which says that every individual who has green eyes and eats a sandwich on a Tuesday evening should be put to the death. Should be put to death. That is a law. It is a procedure that is established, but there is nothing just, nothing fair, nothing reasonable about it. And so procedure established by law has come to now mean due process, which means that substantively and procedurally, there must be fairness to the laws that are promulgated and the laws that govern all of this. What does this mean specifically with respect to the death penalty is something that I'll come to. But before we move on to the procedure established by law that govern the death penalty, I'd just like to come back to the Constituent Assembly debates to say that the death penalty itself as an issue was not something that was considered in and of itself. But what did happen was a conversation about the death penalty when the Assembly debates were looking at the expanse of the Supreme Court and its appellate jurisdiction in criminal matters. And many members were of the opinion that given that we have the death penalty, the Supreme Court must necessarily be a forum that is available as an option for a person on death row. And that right should not be foreclosed because it's an additional procedural safeguard, is what they argued. Then there were those who argued that that would sort of burden the Supreme Court. You can't have the Supreme Court listening to all matters of the death penalty. And then there was a third group of people who, including Dr. B.R. Ambedkar, who were of the opinion that given all of this confusion, perhaps it would just be best to abolish the death penalty and act of violence of the state at the end of the day. But that conversation sort of never really went further as a conversation on the death penalty itself. And what ended up happening is that the Supreme Court now has a provision in Article 134, which recognizes when the Supreme Court as an appellate authority is available as an option for a person on death. I'm only saying this and looking at this Constituent Assembly debate to sort of say that in the understanding of our Constitution, there is a recognition of the death penalty, not only in these debates, but also in the fact that Articles 72 and 161, which guide the role of the President and the Governor in deciding mercy petition of death row prisoners, or in Article 134, which recognizes the right of death row persons on death row to appeal, sort of inherently have the language of the death penalty within the Constitution as it stands. So now let's come back to Article 21 and the procedure established by law. What is this procedure established by law, and is it just, fair, and reasonable? Really, that's at the crux of understanding the constitutionality or debating about it. Broadly, the law, so to speak, could be your legislative acts of the Criminal Procedure Code, which is the basic fundamental code that guides all criminal trials in our country, and the jail manuals, which are state specific because jails are state subjects in our country. So you have the CRPC and you have the prison manuals on the one hand, and you have judicial decisions which have become precedents and which sort of guide how the death penalty must be considered in a case before a judge. So the procedure established by law as understood in Article 21 is a procedure that is established under the Criminal Procedure Code, the prison manuals, and judicial decisions, broadly speaking. So let's start by looking at some of the legislative provisions within the CRPC that are not necessarily always specific to the death penalty, but have some of which are, some of which aren't. But what a combined reading of these will reveal is that the death penalty, even within the imagination of the Criminal Procedure Code, is an exceptional punishment, which has certain exceptional procedural safeguards. The first of these provisions is Article 235(2) of the Criminal Procedure Code. And Article 235(2) basically does a very fundamental thing, which is that it divides a trial into two parts. The first part of a trial is when we consider whether a person has actually committed the crime or not, which is when you look at the process of going through the evidence pertaining to the case in question. That's the first part. Now you go through this entire trial and then you hold a person guilty of having committed the crime that they've been tried for. And then comes the second process, second part of the trial, which is the sentencing part of the trial. And this is the stage at which judicial discretion plays a role, and a judge is supposed to determine what is the appropriate punishment to impose on this person, given that the crime has in fact been proved beyond reasonable doubt. And our section 235(2), by virtue of bifurcating this trial, sort of gives this important space to sentencing as this process within a criminal trial that must be considered as a separate and important part. And the relevance of this is something that will become evident as we go on to discuss Bachchan Singh, which is, of course, the reigning judgment on the death penalty. The second provision of the Criminal Procedure Code, which is relevant to death penalty matters, is Section 354(3) of the CRPC. Now, this is a provision which has a very interesting history when we were to look, if we had to look at it from a historical perspective with respect to the death penalty. So the original Criminal Procedure Code, before we got the current one of 1973, the original Criminal Procedure Code of 1898 mandated that when there is an option for a judge to impose either a sentence of life imprisonment or a sentence of death, he or she would have to give reasons for why they chose to give a life imprisonment. They had to give reasons for choosing the lesser sentence and not the sentence of death, and they had to justify doing so. This was in the prevailing circumstances in 1898. As we move further over time, in 1955, now we've already become an independent nation. 1955, the CRPC undergoes an amendment. This provision undergoes an amendment, and they drop this requirement of having to provide a reason for choosing the lesser of two alternative punishments. So the judge has to give no reason either way. They can just choose life or death depending on what was working in their minds and the facts before them. In 1973, when the current Criminal Procedure Code was adopted, the sea change that really came in a roundabout from the original provision as it read was that when there is an option between imposing a sentence of life and death, a judge choosing to impose a sentence of death had to give special reasons for doing this. So there was this exceptionalism created in the legislative intent to say that you must justify why it is that you cannot give a lesser sentence, you cannot save the life of a person, and it is a sentence of death and no less that is warranted in a particular case. This Section 354(3), which is a requirement to provide special reasons in the choice of opting a sentence of death, is again a very, very significant safeguard that is available within the Criminal Procedure Code and which is meant to require judges to apply their minds to why they're imposing a sentence of death. And then another very important part of the Criminal Procedure Code with respect to death penalty cases is an entire chapter, chapter 28, which looks at the role of a high court as a confirming court, as it is known. Because when a court of sessions, which is where the trial happens, imposes a sentence of death after going through a sentencing process and providing special reasons for imposing a sentence of death, when that trial is complete and the sentence of death is imposed, there is a fundamental right, which is that this decision of the death sentence has to be confirmed by a court above the Sessions Court. And that, in our structure of the judiciary, is the High Court. So the High Court sits in what is known as its confirmatory powers, and it has a unique position with respect to the death penalty as compared to any other criminal appeals, in that when it is sitting as a confirming court, it can look into issues issues that were before the trial court. It can also undertake an inquiry procedure of its own. The point of this chapter and this exceptionalism again is to ensure that the High Court must also be convinced that it is in fact a sentence of death that is merited in a particular case and not the alternative of a sentence of life. And what this also means in like a very day-to-day functioning of court kind of level is that, say for instance, there is a confirmation hearing in the High Court in Bombay. The accused are in fact brought from the prison and they are brought to the High Court and they participate in the proceedings, unlike any other appeal that goes before a High Court, where a person whose case is being heard and is in prison does not really have the right or is not brought to the court. So these kind of need to act as checks and balances and to guide judicial discretion on how a sentence of death and when a sentence of death can be imposed. And now going forward in this with the concept of this right to appeal, which existed which is of course a matter of right for the High Court, is also a matter of right in the Supreme Court at the moment because of the jurisprudence that has developed over time. A very recent judgment of the Supreme Court has held that when a case of death comes before it in what is known as a special leave petition, most cases that go to the Supreme Court have to be allowed, and it's not a matter of right, as I just discussed before. So when an SLP goes before a Supreme Court, and this is a case of a person on death row, the Supreme Court cannot automatically, without going into the records, dismiss such an SLP. They must provide reasons for why they think, at least with respect to the sentence of death, that this is in fact a sentence that must remain or not remain. And the second right that is judicially recognized as a right of appeal came about in the decision in Muhammad Arif, in which the review jurisdiction of the Supreme Court, which is that the Supreme Court can take a reconsideration of its own decision, again comes with a special safeguard for death penalty matters, which is that a review hearing must necessarily be an open court hearing, which means that a judge cannot sit in his chamber and decide whether this decision requires a review or not. So all of these exceptional safeguards that are provided in terms of these rights of appeal and options to go above in the hierarchy of the judiciary is also considered to be a very fundamental procedural safeguard with respect to the death penalty. So while keeping these in our minds, which is that there is a bifurcated trial system, that there is a special reason required to be provided in the imposition of a sentence of death, that there are all these multiple levels of appeal that are available as a matter of right to a person who has the death penalty imposed on him. Let us now look at what the judicial standards have been for the consideration of the death penalty. We look at this in terms of the constitutionality of the death penalty itself, because there are multiple cases that go before the Supreme Court where there is a case of the death penalty. But of significance, and one of the earliest challenges to the constitutionality of the death penalty was in the case of Jagmohan. It was before a bench of 5 judges of the Supreme Court. And at that point in time, what the Supreme Court held was that Article 21 and the CRPC provide sufficient guidelines for how the sentence of death plays out. And that therefore there is no violation of Article 21 that they foresaw in the scheme of things as they stood, because Article 21 to them very clearly said that as long as there is procedure established by law, there can be a reasonable restriction on the right to life and liberty. But subsequent to Jagmohan, there were some very fundamental changes that have happened before Bachchan Singh came to be decided. And each of these has like a very significant role to play in how the arguments in Bachchan Singh therefore took a different, more nuanced position than they did in Jagmohan. What were these changes? One was the fact that the 1973 Criminal Procedure Code has now been adopted. And as we've discussed, there is this requirement of special reasons that has now been incorporated. Second was that there have been a few decisions between Jagmohan and Bachchan Singh where the court has been trying to sort of understand what this special reason could be. What could be what they started terming the aggravating and mitigating circumstances of a particular crime. So although there was nothing that was concretely laid down, there had been certain judicial decisions that was moving towards a more nuanced understanding of what a criminal trial leading up to a sentence of death would look like. Another change, which is very fundamental, is that Maneka Gandhi had been decided. And now this was binding on the court, on the bench that was hearing Bachchan Singh. And as I just discussed with you, Maneka Gandhi has revolutionized the way we look at these articles. We have to now look at 14, 19, 21 altogether. They cannot be looked at as silos. And this therefore means that each article informs the other. Not only must the law be a procedure that is established, it must also be fair, it must also be just, and it must also be reasonable. And elsewhere in the world, there were changes taking place. So in the United States of America, the conversation on the constitutionality of the death penalty had assumed significance in the 70s. Because in Furman versus Georgia, the court had sort of held that the discretion that is available to judges in the process of sentencing for capital punishment was so wide that it was unconstitutional and went against their constitutional safeguards of cruel and inhuman punishments. And subsequent to that, there was a brief period of a moratorium on the death sentence in the US, which then again was reversed because by then, I think everybody got wise to the fact that all the courts really were looking to do was to get a more guided sort of sentencing procedure. So sentencing guidelines have become like the norm that was being discussed and debated in the United States of America. And elsewhere in the world, there is this shift towards, if not the abolition of the death penalty, then at least to keep it only in the most limited of circumstances and only after providing certain very basic rights. And before Bachchan Singh was decided, India had become a signatory and had ratified the ICCPR. So all of these changes have happened. when Bachchan Singh and the challenge to the death penalty comes up before the Supreme Court in 1980, which is Maneka Gandhi 1973 amendments, ICCPR, Furman versus Georgia, all of this. So how do these 5 judges in 1980 look at the death penalty and its constitutionality? And how do they reconcile the reading of Article 21 with Articles 14 and 19? What they say, really, ultimately, in a decision that is a 4-1 majority, there was one dissenting opinion. What the Supreme Court held was that we still feel that as long as there is some guidance to this assumed discretion that everybody has a problem with, that is still going to sit well within Article 21, because 21 clearly says that you can, by law, by procedure, restrict both liberty and life. And they believe that Article 19 and the fundamental freedoms that are protected under Article 19 are only incidental rights that are affected when the law and the criminal law, which has a very justified reason for imposing the restrictions that it is imposing in the imposition of the death penalty, is sitting well with this, what they believe is an incidental sort of removal of rights under Article 19. Because if it were an unjustified reason that led to the restriction of life and liberty, then that would be unconstitutional. But the justification and the reason that has been found in the fact that the state has a responsibility in ensuring that a crime is, when a crime is committed, a person is commensurately punished, is a reconciliation of Article 21 to their minds. But what the bench also goes on to say, and this is really the procedure established by law that is laid down judicially, is that they feel that they need to guide the process of death penalty sentencing a little. And the reason they say that they don't want to overguide it is because they believe that that was in the domain of the legislature. The law is to be made by people who are elected and who go into parliament. They're the ones who should decide if there should be a sentencing framework, so to speak. But for the purposes of judicial minds and how they must apply the law as it stands, the court decided that they would provide some broad guidelines. And these broad guidelines are the framework within which the death penalty operates in India currently. So let's take a look at what these basic fundamental guidelines are. One of the things that they see, and again, this is a test that has been evolving, and they've been trying to do it, but becomes ingrained after Bachchan Singh, is the crime and the criminal test. So as we discussed in the CRPC provisions, there is this concept of the bifurcated trial, the trial and the sentencing being a very separate portion. So what the court said is that while there's so much evidence that is available about the crime once you've gone through the trial process, there isn't really that much that we know about the criminal. And you cannot punish a person merely on the basis of the facts of the crime. You need to look beyond the crime and you need to look at the person who is standing before you and who is to be sentenced. And what are the things that you would look for in this person? This understanding of the criminal test is where they start introducing the concept, which again was already there, but sort of expanded on the concept of aggravating and mitigating circumstances. So these basically are the circumstances which are meant to explain and understand how a person becomes the person that they are, and is not meant to justify the crime, mind you. That was never the purpose of the process of aggravation, considering aggravating and mitigating circumstances. It is, however, a process of trying to understand the context in which a particular crime came to be committed and the context in which a particular person has come to be. And again, the court cautions that they don't want to lay down all the permitting and mitigating circumstances that could exist. But some things that they say must be considered as mitigating circumstances would be, say, the age of a person who is before them. If they're very young, then that is not a person who should necessarily warrant a sentence of death. Possibly they committed the crime because of their youth. Possibly they committed the crime not knowing what they were doing. Possibly they have a far higher chance of reforming themselves given the right resources and time. Age is just one of the many factors. They name certain other factors which can be considered to be mitigating circumstances. They don't go on to draw a list of aggravating circumstances that, again, were supposed to be laid down in law as the necessary points, which must necessarily be considered against the accused. But the idea was that both things that are for and against a person as evidence must also be collected by the court. And that must also be present when a judge is to determine what the appropriate sentence should be. So now you'll have the crime test, you have the criminal test, you have your aggravating circumstances, you have your mitigating circumstances. What do you do with all of this evidence? What do you make of all this material or information that may be before you? This is perhaps where there remains quite a nebulous area in the Bachchan Singh framework itself, and which has sort of resulted in many, many years of very different judgments and very similar facts. We don't know really what the weight to be assigned to these mitigating factors, to these aggravating factors should be. We don't know once we assign the weight that Bachchan Singh requires us to assign to these factors. What do you do thereafter? Do you balance these various factors pertaining to the crime and the criminal? Do you provide more weightage to a particular kind of mitigating evidence? Or should the brutality of the crime sometimes override all mitigating circumstances? That process of what should a judge do once he undertakes this process of collecting evidence is something that remains sort of unsettled in Bachchan Singh. But in Bachchan Singh, the judgment's imagination, the sort of very important holding line really is this statement, which is a real and abiding concern for the dignity of human life postulates resistance to taking human life through law's instrumentality. That ought not to be done, save in the rarest of rare cases, where the alternative option is unquestionably foreclosed. This is a sentence which comes right after the majority opinion is considering what can and should be the mitigating circumstances in a death penalty case. And what they say really, and my reading of this sentence, and of course different people read it very differently, my reading of this requirement that the alternative option of life must be unquestionably foreclosed before the sentence of death is to be imposed, to my mind, seems to be the court saying that if there is at all any chance of redeeming a person, which can make you understand the person in less of a harsh light, and if there is any possibility of that person showing a possibility of reform going forward, then that is not a person that you can give. That is not what Article 21 will let you do. And that is not the judicial discretion we want to lay down as a court, is my reading of this requirement of unquestionably foreclosed. So until and unless there is nothing that redeems a person, the exceptionalism of the death penalty cannot give you. Unfortunately, the exceptionalism, as it has come to be understood, has not been dictated so much by by the possibility of the alternative being unquestionably foreclosed, as much as by this now often used phrase of rarest of rare. So the rarest of rare case is a case which is considered to be exception. And how do you understand what is rare? How does one judge decide what might be the rarest of rare in his or her mind as opposed to another? And that's necessarily going to be different, right? Because there is no explanation either in any other legislation that we have today or within Bachchan Singh itself of what this rarest of rare can mean. But what could be a or viable understanding of this requirement of the alternative option being unquestionably foreclosed, to my mind, seems to be that there must be the possibility of reformation of that person. Now, that is, of course, a very hypothetical situation too. How do you sit today and decide if a person can change, if a person cannot change? I don't think the idea of reformation is to necessarily look at a particular person and to say that this person has a chance going forward. As much as reformation as a principle and a guiding light in what a sentencing policy should aim to achieve. And Bachchan Singh does this too, right? They look at all of these various theories that must inform them in deciding the punishment. Should it be deterrence? Should it be retribution? Should it be reformation? Every punishment, whether it is a fine or an imprisonment of a month or sentence of death, each of these has been brought into the legislation for a particular reason. They indicate certain things. They indicate that having these punishments and quantifying these punishments in the way that they have been is to perhaps prevent some people from committing a crime, which is the deterrent value of a punishment. I may not want to steal something because I don't want to go to jail, and I know that that is a punishment that is in the books. But is deterrence really the only role of a punishment? Of course not. We would be kidding ourselves if we do not recognize the fact that a very real and abiding principle behind any sentence and punishment is also retribution. And retribution, in my opinion, with respect to something like the death penalty, necessarily comes with a sort of vengeance, a sort of an eye for an eye, tooth for a tooth kind of logic, which we may try to couch in very different terms, which we may try to sort of hide into the language of Article 21. But the fact is that retribution remains sort of an overshadowing principle in the imposition of the death penalty. And there seems to be no possibility and no chance of looking at reformation and the role that reformation might have as a sentencing policy. And this confusion of what must be guiding a judge, deterrence or retribution or reformation, remains again an unresolved question in Bachchan Singh and in Indian criminal jurisprudence itself. Some would argue that it must be a combination of all of these things that inform how we decide a sentence. But the fact is that in Bachchan Singh, this question had a very significant role to play, because if the court were to say that reformation is a necessary and abiding principle of any sentencing process, then I believe that the understanding of this save except of the sentence which I just read out, which is of the alternative option being unquestionably foreclosed, would have been understood within this framework of the reformative spirit. So this was Bachchan Singh, right? So Bachchan Singh's majority is saying, let's look at the crime and the criminal test, let's look at the aggravating and mitigating circumstances, let's try to weigh all of these circumstances, let's see if there is absolutely no other choice available to us, and then let us impose a sentence of death. And they believe, the majority believe, that this was a sufficient guideline in the existing framework, in addition to the CRPC and its provisions, that was enough to uphold the constitutionality of the death penalty. So what's significant for us in today's conversation and the way things have sort of evolved over time is to look at the dissenting opinion of Bachchan Singh. So Justice Bhagwati writes the dissenting opinion, and he looks more closely at Article 14 and not just at Article 21. And his understanding of Article 14, again, is being informed by how Maneka Gandhi is looking at all of these rights together, and how Article 14 by then no longer remained an article which was about classifying people on reasonable basis. Article 14 had also come to mean that laws cannot be arbitrary, people cannot be treated arbitrarily. And this very fundamental understanding of Article 14 is what informed Justice Bhagwati in his dissenting opinion. And he looks at how different judges in seemingly similar situations have reached different decisions. While some impose a sentence of death, some do not. And he believed that this is necessarily an arbitrary existence within the statutes. And also goes on to say that there is actually fundamentally, if you were to look at it, insufficient guidance. No matter what we may say can be sort of structure for guiding judicial discretion, there will always be scope for arbitrary implementation. And therefore, he believed that Article 14 was necessarily violated by continuing to have the death penalty in our books. And he very strongly wrote his dissenting opinion, stating as much. And subsequent empirical research work in this country have shown very much how this dissenting opinion was right on point. The Amnesty India report, which came out a few years ago, the report that's known as Lethal Lottery, is a report that looks at Supreme Court decisions to say that in seemingly similar situations, similarly situated cases, different judges have arrived at different decisions. And that was an analysis of Supreme Court decisions over a period of time. And more recently, in 2013, the Death Penalty of India report, which was a remarkable effort that was an exercise where persons on death row and their situations were studied, sort of came to this conclusion that if you were to look at the kind of person who ends up being on death, then that's very telling of the disproportionate burden that a sentence of death has on certain kinds of people. So as per the findings of this report, I've shared the report with you, and I hope some of you had a chance to read the report. If you were to look at factors of whether it is economic vulnerability, or you're going to look at things like the number of people who belong to SC, ST, OBC, or vulnerable or minority religions, and that vulnerability. Or if you were to look at the education and education profiles of a lot of people that were studied, all of this revealed that somewhere around 75% of the persons on death row in India at the time that the study was conducted in 2013 is when the report came out. About 75% of most of the people on death row come from these very different vulnerabilities. Only to say that the disproportionate burden that a sentence of death has is very much also at the root of an Article 14 violation of a sentence of a person's rights. And so therefore, whether it is the judicial vagaries that exist, or whether it is about the kind of person who ends up being on death row, there is a very clear Article 14 violation argument that can be made about the death penalty, even if you can try to sort of articulate that Article 21 seems to be fulfilled with all of these different safeguards. Now, it's also important to see what happened post Bachchan Singh. So Bachchan Singh has laid down all of these different criteria for how a sentence should happen. There seems to be this consensus that there is of course subjectivity involved, and that subjectivity is fine as long as it is guided. But post Bachchan Singh, instead of taking the spirit of Bachchan Singh and sort of taking the spirit of this exceptionalism of the death penalty forward, what we see is in fact the opposite. Very similar to a lot of these simple guidebooks that we have for our college textbooks. Post Bachchan Singh came a decision called Manjesh Singh. Manjesh Singh sort of is like a much simpler version of Bachchan Singh, which attempted to perhaps provide how Bachchan Singh is to be implemented. And in doing this, what it came up with is the concept of a balance sheet. So the balance sheet of aggravating and mitigating circumstances is a creation of Manjesh Singh, which was not a bench of 5 judges, as was the case with Bachchan Singh, but a bench of 3 judges. And they were not looking at the constitutionality of the death penalty. But what they were trying to do was to say, how must Bachchan Singh be implemented? And because of the fact that there has been this confusion of how to weigh all of these various different aggravating and mitigating circumstances, Manjesh Singh decides to simplify it by reducing all of these into a balance sheet where you have to consider the aggravating and mitigating circumstances of the crime and the criminal, and you come to a conclusion about whether a sentence of death is sufficient or not, and you provide a special reason for this. Now, the problem with this simplification is really this. The idea of looking at mitigating circumstances is not to say it is at par as an aggravating circumstance. It is not to say that it is to get 1 point here and another point here, but it is to sort of have a more liberal understanding of what is it that makes a person commit the kind of crime that they do. And this is not something that can be answered easily. It's not like I have a solution to this, and it's not like lawyers, this community will have a solution, or judges. And the point I'm trying to make is that understanding a person is an exercise unto itself. And one of the things that the American jurisprudence does, which is an example that I keep going to, not because it's a better alternative, but it is because it is a democratic country that still continues to have the death penalty debate about it, and therefore is perhaps somewhere to look at for us. If you were to look at how the American jurisprudence looks at this process of collecting mitigating evidence, it is an exercise that is imagined as opposed to just an enumeration of facts. So the example that I've given you already of age, say for instance, in a lot of the judgments, if you were to look at the Supreme Court decisions or High Court decisions, will always state such things, such as the person was of young age 24 or the person was of old age 56, which tells me literally nothing about the person except the fact that they were of a particular age. If I were to, however, embark on a process of mitigation with the help of persons who are trained to do this or who may have a better understanding of how to do this, which could be a mental health professional, which could be a person who's worked in the social sciences, it might lead me to understand and look at this person very differently. And that is the imagination of a mitigation investigation in American jurisprudence, which is that you look at the life of a person. You try to collect as much information as you possibly can about that person. What was their childhood like? How did they grow up in the home that they grew up with? Did they have family support? Did they have social support? Did they go to school? Were they bullied in school? Did they have friends? Did they have a way of making a life going forward? Did they have any mental health issues growing up? Many times mental health issues may not even be evident and is perhaps something that is discovered in this process of a mitigation investigation. Did they undergo any trauma themselves? We're looking at the accused, of course, but they themselves may have undergone trauma at a particular period of time or multiple instances of trauma. Is that what is playing out? A thorough investigation really takes a lot of resources, undoubtedly, but is also what is the very fundamental basis of a mitigation exercise, which is that you don't look at a person as just somebody who was young or somebody who was poor, but you look at the person and his life, and you try to contextualize the person within this lived experience of that person, and try to see, is this a person who, given some chances in life, might change and might never commit a crime of this gravity again? And it is something that we as a society also owe to him. Because while there is, of course, a need to punish, which is an obligation of the law, the need to punish must also come with it the need to bring that person back into society, which is the reformative spirit of punishment. And the reason I'm trying to say that this mitigation investigation and this exercise of mitigation is important is because the decisions post Bachchan Singh, using this Manjesh Singh balance sheet calculation or using just this enumeration of factors, has sort of again diluted the few procedural safeguards that Bachchan Singh did provide to us in trying to contemplate what is a criminal and what are life's circumstances of that criminal. And what this results in is therefore to go back in time before Bachchan Singh and reduce everything that has been laid to just the crime, which is that maybe this person is young, maybe this person is poor, but look at the gravity of the offense. This is a person who's committed an X number of murders, or is a person who has sexually offended with a child. They're not easy situations, and there is no excuse for these situations. But the fact is that the crime overwhelms in this entire process uh, of sort of guiding the sentencing process. And it becomes this because we do not have a robust system of ensuring that mitigation is something that is done as a process, not just as an enumeration of facts, but also as an exercise, but and also to do that at the trial court level, where we have this opportunity of a bifurcated trial, where there is supposed to be a separate hearing for sentencing, and where there is supposed to be this collection of evidence. And I suppose that's one of the real and abiding concerns of people who are on death row right now, which is that nobody's really looking at their lives, and nobody's ever going to present their lives before a bench. And all their decisions are really actually going to uh, result from just the facts of the case that they have been convicted for. Of course, there are many efforts that are being made to sort of counter this, and the Project 39A, which sort of ended up taking up matters of death row prisoners and fighting their cases in the courts, now look at litigation as a process of investigation. Have been trying and making attempts to sort of make this the practice in Indian jurisprudence as well. Another concept that I wanted to talk about, which has become this norm post-Bachchan Singh, is this concept of the collective conscience. Very similar to how brutality of crime becomes this overarching, sort of overweening reason to decide a particular way, is how a lot of judgments end up deciding how they do on the basis of this purported requirement by the collective to sort of seek death penalty and nothing else. And this is problematic, right? Using the phrase collective conscience and looking at judgments and deciding on the basis of the collective conscience is very problematic, because this is ultimately, at the end of the day, a form of mob justice. Pure and simple. We're crying for blood and we're going to get blood, which is not the point of having a democratic government in which we have civil rights, in which we have due process rights, in which we have a judiciary that is supposed to be independent, and which is not supposed to abdicate its responsibility to what the people want. The role of a judge is to be an arbiter of facts of the person, and not somebody who's supposed to give voice to what the collective thinks must be the sentence imposed, because the collective does not really have all the facts before them. They don't know this person who's on death row. They only know the crime, and they only know the crime as it is reported. So collective conscience has become this concept that sort of seems to be being either explicitly or sometimes otherwise, because if you were to look at the kind of cases in which a sentence of death is given, every case which has a lot of hype and a lot of media attention will necessarily, not necessarily, that's an absolute term, but more often than not result in a sentence of death being imposed, if not finally being executed, but at least being imposed by a court of session, which may, over a period of time in this long winding process of the appellate system, get commuted to a sentence of life. But it is still a very abiding concern, and that is another problem that has emerged in the post-Bachchan Singh framework. So I think with this, I'll sort of move away from Bachchan Singh and talk about some of the other issues that I think are also relevant to and which are of course related to the constitutionality of the death penalty itself. Some just very basic things without really going into great detail is the fact that in India we do not have a mandatory death sentence that has been ruled to be unconstitutional. So we cannot have a law that states that a person must necessarily be given a sentence of death for any particular crime. And in statutes that have sort of tried to bring this in, the judiciary has interpreted it to mean that it cannot be mandatory, it can only be an alternative punishment. So there is no mandatory death penalty in India. Um, that's sort of going to take me to the next part of this conversation, which I thought would be of interest to all of us, which is of mercy petitions. So we have a sentence of death and its appellate process, which is a judicial process, sort of space where remedy is available to a person on death row is in the mercy jurisprudence that exists. The Constitution recognizes two offices that have the power to sort of look at decisions, look at sentences, and grant mercy. It isn't only, it is also for other sentences, but it assumes significance, grave significance in questions of a sentence of death. So, the President has the power to grant mercy, and under Article 161, the governor of a particular state has this power. Now, what is the role of a governor or president in deciding a mercy petition? This is really an act of grace that is recognized in the Constitution. So once a person has exhausted the judicial remedies and they feel that they still want to seek a right of forum before a particular person and ask for their sentence of death to be converted to a sentence of life, they can make an application before the governor first, and once it has been decided by the governor, then it goes to the president. By virtue of these being recognized as constitutional functions of these particular posts, and by virtue of this being an act of grace and not necessarily a matter of right, and by virtue of how the Constitution is designed, the basis of the reasons which form the basis of why a governor or a president may decide a mercy petition the way they do cannot be looked at by the court. So if a president decides a particular way on the basis of a reasoning that is working in their own minds, then that cannot be questioned. But what can be questioned, again, as per Article 21 of the Constitution, is the process by which this decision has been arrived at. And while there has been a strengthening of process in the appellate system, in the trial system, there has also been a simultaneous strengthening in the process of how mercy petitions are to be sent forward and are to be accompanied by documents and are to be understood and how they function. And a very important decision in this regard of the Supreme Court is Shatrughan Chauhan. So in Shatrughan Chauhan, what the court was looking at was where is it that the court can review a mercy petition's decision? And what are the circumstances that a mercy petition must also necessarily consider, and what are the processes by which this should happen? And they came up with this concept, which is known as supervening circumstances. So what the Supreme Court holds is that if a person is suffering from mental health conditions, and we're talking about persons on death row. So if a person is suffering from a mental health issue, if there has been undue, inordinate, unreasonable, and unexplained delay in the time that it has taken for between the mercy application being made and the application being decided, or if a person on death row has been kept in solitary confinement, which is a punishment over a punishment and is not permissible in the law as it stands, all of these various different circumstances have been considered to be supervening circumstances, which means that if a person on death row has exhausted their remedies and the sentence of death by the judiciary has been finally confirmed, it still does not mean that that person is executable. There is certain other fundamental basic criteria that must be met before a person can actually be put to a sentence of death. And all of these also emanate from an understanding of Article 21, not just in terms of due process, but also in terms of what is the substantive right to life and dignity of a person. So if a person has been waiting, say, for instance, for over 10 years on a mercy petition, not knowing what has happened to it, not knowing the fate of that mercy petition, what the court holds is that that puts that person in a state of confusion where they're living from day to day. And that is a strain on the person that must be accounted for and must be read in favor of the person and must lead to the commutation of the sentence of death into a sentence of life. Or, for instance, the manner in which mental health has been considered. So, if a person suffers from a particular mental health condition, then that person is not executable. And that would be a very fundamental violation of the dignity of that person. Very similar to, say, how you wouldn't put a woman who is pregnant uh, to death. So, there are certain exceptions that the law is sort of, again, still carving out this whole idea of exceptionalism that is so inherent to death penalty. But the law is sort of saying that even after a person has exhausted all of these judicial remedies, he or she has been sort of given the sentence of death as the only option. There are certain things that must be ensured before the person is actually executed. So this is about supervening circumstances, but also this decision of Shatrughan Chauhan is important because it sort of also provides for some procedures that are necessary before the executability of a person becomes a reality, which is something as fundamental, say, as the fact that a person who is making a mercy petition must have access to legal aid. Because if I'm a person on death row, I'm in prison, I may not necessarily have the resources or know how a mercy petition has to be supported by the right documents, what is the language that I must be using, how do I make this a robust petition. So if I am on death row and I am making this mercy application, I must have access to legal aid. And the fact that all the relevant documents about my stay in prison, what has my behavior been in prison, in addition to the copies of the judgment of the crime, etc., must also be part of this information that is sent to the office of the governor or the office of the president, as the case may be, in order to make sure that the decision that they will make, whatever that decision may be, is completely informed by all existing and available information. And then there are also certain procedures for when the mercy has been decided, and perhaps it has been decided that the mercy has been rejected. How is it that this information is to be given to the person on death? It must be in writing. It must be, once this information about the mercy rejection has been made to the person on death, there must be a period of 14 days between then and the date of execution, which is to allow this person to make all necessary arrangements to meet their family, take care of their obligations. And in fact, even after death, Shatrughan Chauhan provides for certain procedures after the execution of a person, which is that there must be a post-mortem of the execution that is conducted. So what has basically happened is that there is this whole body of jurisprudence that has grown with respect to mercy petitions and how mercy petitions can also be challenged by the court and the circumstances in which the court can consider a mercy petition. Another issue that is relevant from a constitutional perspective is the manner in which a death warrant can be issued. So the date of execution is supposed to be set. You're supposed to be given these 14 days time. But at what point of time can a warrant of execution, which is called a black warrant in some terms, when and how can that be given? It's basically a warrant that is issued by the Court of Sessions that originally gave you the sentence of death. And it has to happen only and only after person has exhausted all legal options available to them. And as we've discussed earlier, that option includes going to the High Court, going to the Supreme Court, and a review of the Supreme Court decision. And secondly, there must also be an exhaustion of all of these mercy petition routes, which is that there is the chance to go before the governor and then to go before the president. And there must, again, at this stage as well, when this black warrant is issued, there must again be access to a lawyer so that you are able to, as a prisoner on death row, gauge your options, know your options, and then challenge this warrant of death if that is important. So, I mean, I think the reason, I'm sorry if I'm confusing all of you or boring you with all of this information. The reason I wanted to sort of go into the mercy petition or the death warrant route is to say that there are very significant procedural safeguards that the court, over a period of time, and all of these various directions from the Ministry of Home Affairs, all of them are trying to sort of make the process of this death sentence procedurally as fair and reasonable and just as they possibly can. And one could argue that regardless of the fact that we're doing this, regardless of the fact that the procedure is becoming fairer and fairer, there is still, of course, always a chance that a person can slip through the cracks. And that is true of a system as complicated as our criminal justice system. And what these procedures may do is to sort of tighten those screws and make those gaps and cracks a little less wide. But if the executive were to put its mind to it, there is nothing that would stop them from sort of ensuring that all of these processes and procedures are completely complied with and still sort of hurry the process of an execution. And so, in my opinion, what I really think is that no matter how much you improve the procedural safeguards, there will never be a moment where you can say that this is a system that is 100% infallible and the sentence of death will necessarily not be non-arbitrary. And I think that's where, to my mind, the sentence of death, the manner in which it is imposed, the manner in which mercy petitions are decided, all of these things seem to be very much against the grain of Article 21 and definitely against the grain of Article 14 of the Constitution. But be that as it may in terms of the constitutionality of the death penalty, there are certain other rights of a person on death row which sort of become scapegoats and become sacrificed in this whole process and procedure that sort of engulfs their lives. So a person on death row necessarily ends up spending several years waiting for this judicial process to sort of be exhausted and the mercy process to be exhausted. It can be many, many, many years. And while they're waiting for all of this, of course, a person on death row is still inside prison. They're sitting inside a prison, much like every other prisoner, very much like a person who is on a sentence of death. And there is nothing to distinguish them inside prison, except for the fact that one is serving a sentence of life and the other is serving a sentence of death. And while law must not treat them differently while inside the prison by the Supreme Court's own decisions of how the rights of prisoners are protected, the reality is that a death row prisoner is treated very differently in a prison, both in terms of what the prison manual allows them as rights and, unfortunately, as it turns out, in practice. So I thought one of the other important issues for us to touch today would be about some of these rights of a death row prisoner that are affected in his or her life inside a prison. And again, one of the most important issues about this has been highly litigated in this country, and that is the question of solitary confinement. So once a person has entered a prison, there is this concept of a prison within a prison, which is a cell, which could be an andheri cell, an anda cell, or whatever it may be called in that particular prison. But that is a cell where they may put the prisoners who they think require to be punished even within the prison for some behavior that they may have exhibited while in prison. It's a mechanism of ensuring some level of compliance within the prison, and is something that the superintendent of the prison has authority to impose as per procedures that are provided in the prison manuals. But one of the things that used to be a practice with persons on death row was to put them in such cells, in solitary confinement, disallowing them from meeting other prisoners, mingling with other prisoners, engaging with prison life and the limited prison life that one can expect to have. And as far back as 1980, the Supreme Court has gone against this practice and said that you cannot impose an additional sentence on a person who is on death row by putting them in solitary confinement, because they're going to be spending so many years perhaps waiting for their process in the courts to reach a level of conclusion. And until and unless that date of execution, which we've discussed, once a death warrant has been issued legally, validly, and justly, once those 14 days have been given, in that period of time when they're preparing you for execution, perhaps then you can be kept in a separate place, which is provided for in the prison manuals. But until that time is fixed, a person on death row cannot be and should not be kept in solitary confinement. And even though Sunil Batra was decided 7 years ago and has held solitary confinement will be unconstitutional for death row in the prisons in Karnataka, all the persons on death row uh, are lodged in the Belgaum Central Prison. And even after Sunil Batra was decided, several of them have spent several years in the Andheri cells, which are inside the Belgaum prison. They were not allowed to meet other prisoners. They were not allowed to take part in prison activities. And it was only in 2014 when Shatrughat Chauhan, which we've discussed again, came to the Supreme Court. This practice was brought to the notice of the Supreme Court. And this is true of many, many prisons, not just Karnataka. I was just using that as an example, where the court realized that solitary confinement continued to be something that death row prisoners had to face in addition to this long wait of figuring out what their fate would be, and immediately issued directions to all prisons wherever persons were death row persons would be kept in solitaries to sort of ensure that they would not be kept in solitary. But again, this requires constant judicial intervention, oversight mechanisms by persons who are involved in prison reform movements, and that's something that a person on death row is to be protected from within a prison. Certain other rights of a death row prisoner to be protected are the right to work, the right to study, the right to parole, the right to furlough, the right to remission, which is the right to have a sentence reduced, in the hope that perhaps the sentence at some point might be converted to a sentence of life, are again all very important rights. Because when you're in prison, your life there depends on the work that you're allowed to do, if you're allowed to study, if you're allowed to go and meet your family for a few days on a parole, which is a sort of break from prison when you come back. All of these very fundamental basic rights that a prisoner enjoys are not available to a death row prison in several states of this country, either because the prison manuals do not allow it, or because they've sort of come out with these guidelines creating exceptionalism for death row prisoners and saying that, because of the gravity of the offense and the fact that this is a person on death row, they must be treated differently. And all of these go really again to the root of a violation of Article 21 of persons on death row. And another concept that I sort of wanted to talk about, and I'm going to slowly wind down my conversation with this, is the evolution of a new punishment, which the Supreme Court has now sort of started coming out with, which is a fixed term sentence under the decision of Sriharan. So in Sriharan versus Union of India, the Supreme Court sort of came up with this via media solution for what to do between a sentence of life and a sentence of death. Because a very common misunderstanding or understanding of a sentence of life is that a person will only serve 14 years and at the end of it, that period is over, which is not the case. A person who is sentenced to life may spend actually the rest of their whole lives in prison, but as long as there is a process of review of their sentence, it is possible that they can come out in after having served a few years, because a prison manual has a complicated system of accounting for good behavior, work done in prison, and calculating all of these in the time that they may have served. So traditionally, a person who serves a sentence of life has this opportunity of being released after a few years, mandatorily after 14 years, but it could also be 20 years, it could be 25 years, etc. But what the court has done in this reimagination of the sentence in Sriharan is to say that they will now fix and cap the number of years that a person who's perhaps not fit to be a person on death row, but is also not a person who can get the lesser punishment of a sentence of life, and is therefore a person who must be given a fixed term sentence. So if, say for instance, a court says for 25 years, this person will never be considered for release. That is a she/her sentence. Or the court may even impose a condition to say that this person will never be considered released. So the reason I thought it was important to discuss Sriharan is because this is a punishment that is slowly being opted for by the Supreme Court in a lot of different cases, with a sort of curtailing the right of the state executive to decide when a person who is serving life may be eligible for release. And there is a very rigorous process to how states determine this and how sentencing review happens. But the Supreme Court, by imposing a punishment like Sriharan, has decided for itself that it will not give the executive this power to ever decide what could be the fate of a person who is serving life. And more importantly, again, goes against the very grain of the reformative spirit of a sentence that may be imposed, which is to say that the court is deciding today, looking at the facts of the case, that here is a person who will not for sure ever be possibly reformed for the rest of his life. So I won't kill this person, but I will ensure that he will never come out of prison. And arguably, I don't know if this is really a choice that is so simple and easy to make for any person, uh, whether it is a person on death row, the lawyer representing the person, but the court has decided to start imposing the sentence. And what this has also meant is that slowly this language of life without remission or life till the end of life are these are the kind of phrases that and concepts that have sort of seeped into other places. And by other places, I mean mercy rejection petitions these days say that while they are commuting a sentence of death, this person cannot be released until they die. So there's never a possibility of reform, never a possibility of reviewing the sentence. And curiously, also criminal law amendments that have happened in recent times has started using this language of life, and which means until the remaining period of the person's life. Um, and what this has really started meaning is that although there has been this move against death penalty and this push against death penalty, whatever may have been the victory in getting commutations has now sort of started converting itself into these extremely inordinately long periods of sentence, which it is also, to my mind, a violation of the Constitution and the right to ever be considered for sentence review. In, in addition to, of course, imbalancing the federal structure of how prisons are to be administered in this country. I'll just end by looking at a couple of developments that happened in 2018, which I think are important for us to know, which is that in 2018, first there was an ordinance to the criminal law, but that subsequently got enacted as an act. There was an introduction of a new section into the Indian Penal Code, which is section 376A, which specifies that a sentence of death can be imposed if a man commits a sexual offense against a woman below the age of 12. So until now, sexual offenses have warranted a sentence of death only when it has been coupled with reducing a person to near vegetative state or when it has been coupled with death. But this introduction in 2018 has meant that if there is rape of a girl below the age of 12, a girl, not a boy, only a girl, if that is the case, then the sentence of death may be imposed. And also in 2018, the United Nations moved a resolution for a moratorium on the death penalty. It happens very routinely in a few years, every now and then. 120 plus countries signed this moratorium. So even though their statute books may have retained the sentence of death, some countries sort of have this moratorium where they don't implement the sentence of death. But India, sadly, was not a signatory to this resolution. And I think the reason I wanted to sort of bring these before I ended was to say that we are seeing more and more that the government is sort of introducing all of these provisions in which the sentence of death is being brought in for sexual offense, instances of sexual offense. Of course, terrorism has always been a pet peeve where sentences of death have sort of always been protected, even by law commission reports that say that death penalty must be abolished for everything but for offenses of terror. And again, sometimes there are conversations about how a sentence of death must be introduced in certain provisions of the Narcotic and Psychotropic Substances Act. So there's always this push that seems to be happening in India, much against what's happening in the rest of the world, where there's this move towards an abolition. In India, we seem to continue to want to retain a sentence of death, and I believe that this exceptionalism that we statutorily see or sort of judicially see is an exceptionalism that no longer seems to remain with this sort of growing need to want to introduce the death penalty in a lot of different instances. And I suppose I'll just end by saying that by virtue of the kind of persons who end up having to bear the brunt of a sentence of death, and by virtue of the fact that you can never say 100% that this process can be perfect, because there will always be that space of judicial discretion. I think that continuing to retain the death penalty in a country like ours, with so many complicated issues of identity politics, power politics, religion, and of course the very complicated and fractured criminal justice system, really to me means that continuing the death sentence would be a violation of Articles 14 and 20. And so I believe that it is unconstitutional, and I hope that in the near future, this is something that the courts will take up, or there will be a legislative redefinition of and reimagination of a sentence of death. So I think I'll stop here and ask, sort of take questions, and maybe we can do that.
Great. Thank you. Thank you so much, Sahana, for walking us through the entire constitutional framework within which death penalty in India operates. To just summarize what we've learned or what we've understood in the last hour and a half is that, Sahana has traced for us the evolution of the jurisprudence pertaining to the death penalty through her introduction of the CAD debates, the criminal law amendments that have happened over the years, as also Supreme Court precedents. And there was also the emphasis on adopting reformation as an abiding principle in sentencing policies. And she's demonstrated to us how adopting reformation as an important influence in sentencing policies can change the case for us. We've also looked at other constitutional issues, more importantly pertaining to the constitutional rights of death row prisoners and how that fits into the larger context of death penalty and its constitutionality. So thank you very much. We can now take questions or comments. So if any of you have any thoughts to share, you can either raise your hand and I can unmute you and you can have a direct conversation with our speaker, or you can put your questions and thoughts into the comment box. So, right, so we have a question here that says, can you please discuss the execution of Yaqub Memon if time permits? Could his sentence not have been commuted to life imprisonment given the extent of his involvement in the conspiracy? Would you like to weigh in, Sahana?
If I understand the question right, I think you're trying to say that given the limited role played, therefore it must be reduced. Is that the question? Yeah, okay. Yeah, I mean, I think there will be people who will have a lot more to say about this case and how this case came to sort of play out the way it did. Yes, of course. If you were to look at actually one of the theories that is considered in a lot of death penalty cases, it is about this ascription of role, which is that you have multiple accused in a case. What is the particular specific role played by that person in the commission of that crime? And is that role sufficient for us to continue to impose a sentence of death? Or alternatively, is that role even clearly defined? And of course, in something like a conspiracy, it's very difficult for anybody to lead evidence to sort of ascribe individual responsibilities for what is a collective act. And in some matters, what the courts have done is to say that when there is no clarity on exactly who has committed which portion of a particular crime, that must necessarily be considered to be a factor for us to commute a sentence of death. But again, this is something that can play one way or the other. Some courts will hold this, and some courts will hold otherwise, and say that given the gravity of the offence, even if it's not, we may never be sure about what the particular role of a person is. We think that the sentence of death is warranted. And I think in Yaqub Memon's case, of course, given that it was a question of terror offense, it became a very different kind of question altogether. And interestingly, also, I mean, there are many violations in how Yaqub Memon's execution came to happen. But like we were discussing about Shatrughan Chauhan, something that a lot of people have raised as a cause of concern, an obvious cause of concern, is the fact that this was a person who, on paper, in the jail's own records, was suffering from a grave mental health condition, despite which his execution was carried out. And the law on this was already clear. So I think there were quite a few injustices there. I hope that answers your question. Purna, I think you have to unmute yourself.
Oh, right. Sorry. I was saying thank you for responding. And I was asking the rest of them if they have any other thoughts or questions. While I wait, perhaps there's something that we as a group, while we're talking about the Constitution and the challenges that we face in taking it to the people, if I could just, transpose it with the context with death penalty. There are two ways of looking at, death penalty in India today, which is one to fight it out in the courts and try and address the loopholes in the system with legal help and competent counsels, etc. But on the other hand, how do we work towards changing the perspective of the general public towards death penalty? Because even today, a lot of us are saying extremely problematic things about death penalty as a form of punishment. Even when I put this out on social media to ask people to come listen to us, there's one person who said, death penalty doesn't work because we're doing it in closed chambers. And if we were to hang people in the open, then that's going to be a great deterrent. So we're still going back to very fundamental ways of like engaging with it and arguments of this kind. So how do you think we can change common perspective on death penalty? If you could just give us a few thoughts on that. You are on mute.
Okay, sorry.
Yeah.
I don't know really how public perception is made or broken, to be honest. I wish I did. But I think one of the things that would really sort of inform us, maybe, if we were really interested in understanding how the death penalty works, whether it really is effective, is perhaps to sort of try to understand the kind of person who ends up being on death. And I feel that might, I don't know if it will, but I feel that might humanize the person, make that person a little less of a demon than we would all like to believe. And perhaps that might sort of change our perception, because if we were to know that tomorrow you or I could face death, and the kind of lives that we would live, perhaps that's something that would make us think otherwise, right? Because right now, in the public imagination, a person on death row is somebody else altogether, somebody whose caste, class, economic background is going to be so different from ours that we may never really try to understand that person. And of course, it may not be the onus of the public to try to understand the person, but if it is a question of perception building, I think if we can stop looking at just the offense as it is, and to look at the offense more in terms of placing it in context of structures that allow for it to happen, as opposed to just that one person who's committed it, I think that would be a far more useful exercise. Right. Because I think it's also very easy, right? It's very easy to just say execute a person. That is the person you need to kill because we don't want to look inside and look at how we've led to this, I'm sure, unfortunate crime that this person is speaking of to have happened.
Hmm. Sure. Yes. Thank you. Arvind has raised his hand. So, Arvind, do you want to unmute? And
yeah, fine. Yeah,
yeah.
I think
Yes.
it came unmuted.
Yes.
Thanks, Sahana, for the really fantastic overview of the entire law around the point. Again, I thought it's very important and very useful because I think linking up to Purna's question, it is a very, very difficult issue. And I was thinking back to one, I think, presentation by a very long time ago, Bikramjit Batra on the death penalty,
Right.
and very, very fascinating. I mean, it was a discussion we were having on social movements and the law,
Right.
and this entire presentation was about really working with small groups of people, in terms of how you influence policymakers, how you influence, uh, how you influence lawmakers, how you influence, how you can bring to bear a certain kind of thinking on the judiciary, etc. So his
Right.
point was really this: this is not a people's issue. That's the
Mm-hmm.
reality. This,
Right.
and Balgopal's point, one level further, civil liberty is not a people's issue.
Right.
It's a far more smaller group of people who are really concerned about this as of now. We hope that one day it will be a people's issue, but
Yeah.
we're really not there. At
Yeah.
this moment,
Yeah.
how do we take this issue forward is really I think, extremely, it's a very challenging task and very, very challenging. So what I think was fantastic about your presentation is, in effect, you said that one way forward is to know the entire structure of what are the ways we can challenge this using the structure that we have and utilize it to the best possible extent. That's one kind of a way forward. But the other way, I think, is the issue of, obviously, the question of, I mean, how do we keep working and challenging and critiquing existing majority in public opinion itself,
Right.
And that task, I guess, we have to continue. And perhaps, I mean, one part of the question, I mean, since we spoke about it very briefly, I wanted to share a little bit about this. I think this film, this book, Just Mercy, and the kind of impact that might have on changing people's consciousness or ways of thinking on
Right.
on this particular on this particular issue. That's one. The
Right.
second question is this question of, since again, Santosh Parrier, also the point is very clear that this is that we have to think of this as a counter majoritarian issue, and this is a classic counter majoritarian issue because, I mean, the majority is not with us. I
Right.
mean, and so what we hope that the minority is with us. Of course, the minority in this case, the judiciary, is also not with us, but they've
Right.
come the closest to coming with this anti-death penalty campaign,
Right.
especially with respect to our judgment in the, how am I forgetting the most important judgment? Person.
Right.
But
Right.
on that point, do you
Yeah.
feel that there's a space for another challenge to the question of the constitutionality of the death penalty?
Right. Okay. Thanks for that, Arvind. Yeah, I mean, you're right. It is very much a very loaded issue, and um, something like Just Mercy, if anybody does have a chance to read it, is sort of an undertaking in which there is a look at the entire process of case, and if you were to really look at what goes behind a particular case, from the time that a person is picked up to the time that the accused is taken to court, and the life that the person has and the life that the case sort of takes on, especially in a politically motivated case, is often very fascinating, of course, and also very telling of how our systems are not always geared to protect the rights of individuals. And yeah, I mean, I would imagine that an exercise of that nature might, of course, also be interesting in India. And I think there has been some attempt towards this in the case of Dhananjay Chatterjee, where there is a belief that it was a wrongful conviction. And perhaps looking at that injustice would be an interesting conversation. And also to say that in a lot of the countries where the conversation of the death penalty has happened, where the moment of abolition has happened, has also sort of come after this revelation of perhaps an incorrect conviction and execution. Coming to the second point, Arvind, about if this, sorry, my video was on. Coming to the second point about a constitutional challenge to it, I wish I could say the time was right, and I wish I could say this is a a court that we could hope to sort of have the right opinion on this. And I don't think that the time is right, to be honest. Given the manner in which they've been deciding some of the matters in the last few years, and not just on the death penalty, of course, and I mean in terms of what is the role of the court been in protecting the right of the individual in a counter-majoritarian situation, I believe leaves much to be desired, and I wouldn't say now is the time for it. But I do hope that the kind of research that's happening, whether it was the phenomenal research that Vikramjit Batra had started off with, and what they unearthed really sort of guided so much that happened thereafter, and the kind of research that Project 39 is doing, I think is one way to sort of build this arsenal of material, so to speak, very similar to how you guys were sort of formulating it with the 377 challenge, right? So you had so many different stakeholders come in and so much sort of depth and variety of material that if the judges were to look at even one of the many things that were before them, perhaps that might change their perception. So I feel that maybe we're laying down the groundwork for it, for sure, and hopefully in a few years' time.
Thank you, Sahana. Right. Maybe we could just wait for a minute to see if anybody has anything else to say. But in the meanwhile, I'd like to thank you once again for that fantastic presentation. We've had a lot of conversations around death penalty through the week, but I think this was one that really was putting into perspective all the fundamental issues relating to death penalty. So thank you for that.
Thank you so much for having me over.
Yes.
Yes,
please go.
One more question. Yes.
Should I ask you to unmute?
Okay.
Yes.
I've been trying to unmute myself, but you didn't allow me to. But
Sorry.
You muted me off, huh?
Oh, no, you muted yourself, but go ahead.
Okay. No. Just to follow up a little bit on that. See,
Yeah.
you mentioned the analogy 377, right? And
Yeah.
one of the important points, of course, is the comparative perspective, both the comparative law perspective and the comparative activism perspective.
Yeah.
So in that sense, I mean, in particular, if you want to take us a little bit through the comparative perspective in terms of both the US and South Africa, right?
Yeah.
US has a very well, I mean, my understanding, very well developed question of working on the death penalty in terms of the amount of work which has been done. And if you could just learn a little bit of that. And South Africa, in terms of the fact that they've succeeded in a constitutional challenge. And how did that happen? Just those 2 points. Thanks.
Okay. So the American system to me is mind-boggling, to be honest. I feel that they're doing some of the best work, and yet they continue to have one of the worst rates of execution in any democratic country. And yes, the kind of work they are doing, and I don't know all that much myself, but from my limited understanding is the fact that one of the things is, of course, this whole litigation exercises. That process, I think, is something that they've developed so well, and the kind of practice procedures that they have. The bar has guidelines to what are the standards that are to be met by a person who is representing a person in debt. And I don't just mean in terms of litigation, I mean in terms of the full gamut of things that a person as an advocate is forced to be doing. And that sort of bar that is set for the requirement by lawyers is also one of the grounds that can be used subsequently by a person on death row to say that they were not adequately represented, and they can show how they were not adequately represented. That is not something that we can do, even though we know for a fact that so many persons on death who don't have adequate legal representation. There's no way for us to prove that. So, that kind of rigor with which a case is fought, I think, is so well developed there. That is something that I believe we can follow. And if we are to even continue to have this aggravating, mitigating model, then I think it was almost like this borrowing of an idea without its principles. So we did borrow the idea of mitigation, but we did not borrow the process by which that is supposed to happen. So yeah, that's something that I feel it differs very much between India and America. And of course, in terms of the kind of work that they do, the empirical research that happens, it's quite quite varied, and their lens of looking at the disproportionate impact of the death penalty is of course race. And if we can sort of really develop a similar understanding of that disproportionality in India in terms of caste, class, minority, that would be something interesting for us to do as well. With respect to South Africa, I think that constitution itself is such a living document in such a dual sense. And I don't mean just with respect to the death penalty. And again, I don't know much about the history of the challenge itself. But their abiding concern of the dignity of human life and the fact that cruel and inhuman punishment is a phrase that they have sort of adopted is something that we don't have. We don't have any the language of cruel and inhuman punishment or punishment as such. We have Article 21, and that's basically the basis of how we look at the sentence of death. So I don't think we have a peg really to sort of scratch at it and say, let's remove that. Because how would a reimagination of Article 21 with respect to the death penalty be? I think that would be something that might be of interest for us to look at. So if we were to challenge, say tomorrow, the question would be of challenging the death penalty. What is the question that would be formulated? Would it be a challenge of a Section 302 of the IPC, which is how it has been so far with Jagmohan Bachchan, where you're challenging a provision with the death penalty, as opposed to challenging the constitutionality of the concept itself? I don't know. I guess that's a language thing that we might. I don't know myself, but it's something surely to think about.
Great. Thanks, Sahana. We have a very longly worded question here, but I think in essence, the person's asking if judges should be made to give a detailed analysis of the mitigating circumstances and the evidence, just to make sure it's not a very subjective judgment.
This is the question of Ashna, right?
Yeah, that's right.
Okay. I have a question about the disconnect between the thought processes of judges and mitigation efforts. Okay. You spoke of how in India mitigating factors are enumerated as facts and judgments, and little is done beyond that exercise. Given the extent of judicial discretion, how would you suggest we could bridge the gap between the personal philosophies of judges on the death penalty and the need for them to empathize and put themselves in the shoes? Would you suggest that procedural changes that compel judges to give a detailed analysis is a workable solution? Or do you think that what is required is more of a change of mindset? Okay, I think it's a bit of both. If a change of mindset would sort of then inform how our procedures can reflect that, right? So if you were to look at the judgments of the Supreme Court, you can sort of see that there are some judges who have the mindset to consider mitigating circumstances and some don't. If there's a person who says that, say for instance, this is a person who has suffered from socio-economic vulnerabilities and goes a little further and gives a little bit of an explanation to what that vulnerability is, then that is a judge who sort of already has a mindset, I would say. But how do you make that a procedural guideline? I'm not so sure, because I think what is lacking, not so sure in the sense then I feel that the gap that is to be bridged really is between the social sciences and the law, or psychology and the law. Because a lot of what we try to say with this whole process of drawing out the life history of a person is to say, let's try to understand the person. And that process is necessarily subjective. It is individualized, because sentencing as a concept is an individualized process. So I don't know how much the procedure can be guided without this gap, of showing why is it, say for instance, that age plays the role that it does. Or why is it that a person's childhood experiences might inform who they are. That link, whether it is to be made, I don't know, by the law or by the social sciences, that link once it's made, which is already there, of course. I mean, criminologists look at this constantly. That's the discipline of criminology. But to sort of bring that more in tune with understanding an, a person in a particular case individually might be one bridge that we need to sort of cross. And the other, in terms of procedural guidelines, yes, of course, we can sort of make it a mandatory thing for when a judge is using a mitigating factor to say what that mitigating factor plays out as. So this whole concept of giving special reasons, I believe, should be a more extensive exercise than just saying, as most judges end up saying, that on weighing aggravating mitigating circumstances, we feel that. On weighing it, how, if you can explain to us, and on weighing it and giving that reason between that link that is being made would be interesting. But having said this, I also am very conscious that that link is not something that's always easy to make, always acceptable. Because, say, for instance, if you were to look at socioeconomic vulnerability of a person who has committed a crime of property, there's a mass murder that's happened of a family because of a land dispute. Socioeconomic vulnerability is something that might be able to explain and situate that person. How does socioeconomic vulnerability explain a person's who offends in terms of sexual offenses? That's not a very obvious link, and that is something that I think requires the imagination. Is this it?
No, so thank you, by the way, for responding to that. Arvind has one last question.
Okay, could you please share a short bit about your readings and why you choose them? I'll go find it. Okay, yeah, I mean, so there were two readings that I've shared. One is the executive summary of the Death Penalty of India report, which I shared earlier with everyone, and I think now Poorna has shared the lottery. And I think
Yes.
Both of those are very important for giving us the empirical evidence to make an Article 14 argument, or if not to make an argument, just for us to understand what is it that happens in the cases that go before the Supreme Court, which is what the lethal lottery is looking at, where they analyze all of these judgments that have been heard and look at the manner in which the factors have been considered by these judgments, and also show us how there is such a disparity in how two different benches may look at cases that are otherwise very similar. That's one thing. The second was the Death Penalty of India report, which, I mean, if you have the time, I would also urge everybody to read the full report. It's an extensive exercise at looking at persons on death. There's a part of the report which is a qualitative report about the narratives of persons on death. But the first part of it is we need to look at this very often used argument, right? That the criminal justice system affects the poor. That's something that we end up saying a lot. But what does it really mean in terms of numbers? And does it really play out? So this was an exercise in which 373 persons on death row were interviewed over a period of years by students out at the National University of Delhi. And after this massive exercise, they've sort of culled out information about the socio-economic conditions of persons on death row, how much were they educated or not educated. And all of these things that sort of then gives us numbers. And these numbers are very telling of how there is a disproportionate impact of the death penalty on particularly vulnerable people. And that's important for us to remember again, because it's not just a question of saying, let's make the processes simple, right? Let's make it procedurally fair. You can make everything procedurally fair, but still there will always be this inherent bias with the justice system and in the judge about who we are going to hold responsible for certain crimes and how do we look at that person. So if somebody from a middle class were committing a crime of passion, and a person of a low middle class or a socially vulnerable class doing it, the judge may sort of relate with the person who comes from his own class so much more differently, right? And they think that imposing a sentence of death may be too harsh, or may actually very instinctively understand that crime of passion and be able to put themselves in those shoes. And of course, the fact that there is a person who can afford good legal defense. So I think I shared those readings because of the value of empirical research and because they're very seminal work on the death penalty in India. And Balagopal, because I don't think anybody can say anything better than he can about a lot of issues. But the reason I thought it would be an interesting read is because in the piece that Balagopal has written about the death penalty, questioning the death penalty and how it works, he sort of asks some very important questions, right? Important questions such as, does deterrence actually work? And is that a principle that actually works when you have a sentence of death? And he looks at, say, for instance, the state of Travancore, the Travancore, I believe it is, yeah, before they became part of India. And he says, let's look at that. They did not have a sentence of death. The kingdom of Travancore, before it became part of India, did not have a sentence of death. It abolished it. And he wanted to look at whether that difference made any difference to the levels of crime. Say, for instance, to sort of rebut the argument that having a sentence of death has a necessarily deterrent impact. But more significantly, he also sort of says that if you were to look at whose role is it in making a just society and ensuring that justice is done in a case of violence, sort of reducing that to the role of a judge in a decision alone goes against the placement of the death penalty in the scheme of things as they stand. Of course, there is a role to be played by the judge, but the responsibility for ensuring that a crime of that nature does not happen is also of a society, and that apportionment of responsibility is important to consider. And I think that also goes to speak about this collective conscience as a concept, right? Like we keep saying collective conscience is a barometer of what the people want. And Balgopal very rightly says that we can't look at what people want only, right? Because that's not necessarily the accurate way of ascribing and apportioning responsibility in this system. And says that there is something more inherent that the law is supposed to do. And what the law is supposed to do is to ensure that there is justice for the victim and that there is also protection of rights of the accused. And I also thought that piece was very significant because of how he says it as it is, which is the fact that we may argue and discuss and debate about procedural fairness, about the death penalty till the crows come home, but ultimately the death penalty is also a very political act. It is a political act that will remain in the hands of people in power. And it is this balance of power that we're sort of trying to ensure with the rule of law. And having and retaining the death penalty is a huge threat to that balance of power because it can be used by a government in the manner in which it chooses. And this is something we have seen in the course of every execution that has happened so far. The December 16 executions happened in March 2020. It was not so long ago. And we know that this is a case that has been rushed through, hurried through in a manner that no other case has been. And procedurally, all the boxes were ticked. Everything went right. The mercy petitions went right. Everything. But if you were to look at the 21 violation argument, you couldn't find one. If you were to look at the sentencing arguments, perhaps you couldn't find the mistake, so to speak. But we all know that this was an inevitable outcome as well. And this is something that we're going to keep seeing over and over in the years to come. And I think that's why Balgopal's piece really spoke to me and how he looks at the death penalty from a very clinical point of view, so to speak, as he starts off looking at deterrence, retribution, and then ends by saying at the end of the day, it is a political tool, and it's important for us to recognize that. Because once we realize that, I think it's easy for us to come to the conclusion that we will be left with a state that is just more and more strict, which is what we're doing, whether it's the death penalty or the Srinagar sentence. Yeah. Sorry, that was my long answer to a very short question. there any other questions?
No, I said no.
Okay.
So although it was long, we thought it was very interesting, and Arvind thinks it was a great answer. We all
Oh.
concur. So thank you so much.
Thank you
There's
all
some
for
comments
having
in the comment section that.
Okay.
Yeah. Please go ahead.
No. Sorry. In the comment section, you were saying.
No. I was just going. No, there's some comments that you can see where people have responded to your presentation and they've said it was a great session. I've also received some on personal messages, all of whom who thought this was a great session. So thank you so much once again.
Thank you for
Thanks also
having
to
me.
all
And
of you who joined. Go ahead.
no, I was just saying thank you, Purna, for organizing
I
this.
was just. Yeah, thank you so much for being with us on a Sunday evening. This is a slightly problematic timing for a lot of us. So we understand also for the speakers, most of whom we invite are practicing lawyers who have very busy weekends. So very kind and generous of you to have given us your Sunday evening. Also, same goes to the participants who joined us on a Sunday evening and made this conversation that very more interesting. So thank you. As you may have seen in the comment section, if you would like a recording of the video, which we will not put out in public until Sahana is okay with it. But if she's okay with it, we'll share it on public forums.
I'm okay with that.
Okay, great. Thank you. So we'll make it accessible in a day or two to all of whom have asked us for it. And if you would like to stay in touch with the other activities that we would undertake as a group, which will be necessarily centered around the Constitution of India, you could share your contact details on personal message and we'll keep you posted. So with that, I think we can draw the curtains on today's event. Thank you so much to Sahana once again and to all the participants who joined us. Thank you.
Bye.
Bye.